A walkout, a muted microphone, and constitution pushed to the edge. In 2026, the quiet ceremonial corridors of India's Raj Bhavans are not echoing with traditions. They are echoing with confrontations. From Chennai to Thiruvananthapuram to Bengaluru, the office of governor, a symbol of political neutrality and dignity, has become the frontline for confrontation. What was designed as constitutional sentinel now stands accused of becoming a political sword. This is not just a political standoff. This is the crisis of the constitutional head. In January 2026, we see a few instances where the governor is in head-on collision with the elected governments of the state, especially in the Karnataka, Kerala and Tamil Nadu. This is with respect to the speech that he has to deliver before the house begins. Okay, so first we will see what are the three instances, and after that we will try to see the background behind this, and we will see what are the case laws behind this, and also we will try to see what are the possible solutions with respect to the current issue. So we will see the first three instances with respect to the issue. There are three instances. The first instance is respect to Tamil Nadu, where the governor Ravi has walked out of the house without even delivering the speech, and this is the fourth time that the governor has walked out of the house. Okay, and what was his major objections? His major objections were with respect to the text, which was laced with the misleading statements of the state investment and the Dalit atrocities primarily, and also the Tamil Nadu Assembly has this tradition of playing the Tamil anthem before the national anthem, to which he had major issue with. Okay, and what was the outcome of this? The outcome was this, that the cabinet approved, the assembly passed a resolution in which only the cabinet approved text was passed. And the second issue is with respect to the Kerala, where the fiscal federalism edit was seen. What was the conflict about? The governor actually, there was 112-minute speech he gave in which he omitted a few paragraphs and he modified a few paragraphs. Okay, so this one there. And what was his major objection? It was undermining the fiscal federalism, and it removed the criticism with respect to the delay in the governors, and also it changed the devolution, the tax devolution as a right, where the government believes it as a right. Okay, and what was the outcome? The CM has accused the governor of being a political agent, and also the cabinet approved version was deemed to be passed. While in the third instance, January 2026, where the Mr. Gehlot, the governor of Karnataka, he read only the first two lines and the last line of the 112 paragraph speech. Okay, and he left the house. And what was his major objection? Where he reportedly objected to the 11 paragraphs that criticized the union decision to replace the MG Narega with the VB Gram Act. Recently, this is one of the major reforms that the central government has taken, where the core of the core scheme, MG Narega, has been modified to Gram scheme. Okay, and a few states, especially the opposition ruled states, are in opposition with respect to this particular act. Okay, and what was the outcome? The Karnataka government has given a statement that this is a black day in the democracy, and the legal expert, while the legal experts actually noted that, see, the first line and the last line have been read, so according to the particular case laws, it is deemed to be passed. Okay, so now these are the few issues. We'll actually see what exactly the constitution says with respect to the speech that needs to be delivered by the governor. So let me just read the article. The article 176 clause 1 says that at the commencement of the first session of each general election to the Legislative Assembly, and at the commencement of the first session of each year, the governor shall address the Legislative Assembly. Okay, now the provision shall be made by the rules regulating the procedure of the House or either House for the allotment of the time for the discussion of that matter referred to such address. So this is the exact article which reads, and now we will actually see a few intricate details. The first intricate detail is the word shall in the clause 1. So it makes this as a mandatory constitutional obligation, okay, and they must inform the legislator of the causes of its summons, and that is why 2026 cases of the Tamil Nadu and Karnataka, the governor's walkout is seen as a delegation of the duty, okay. The constitution actually says that you shall, which means it's commands that the governor has to deliver his speech, and if the governor actually walks out of the House without delivering the speech, then it is considered to be the delegation of the duty. And next one is the timing, which is the post-election before the first session, and also annually before the first session. Okay, so these are a few details, and the second detail that we need to look at is, firstly, it has to inform the causes of the summons, okay, and without actually, so if you are actually summoning the House, now why are we summoning the House, okay, what are we going to discuss, what are our plans, okay, so in this address you will have to inform that. So governor on behalf of the government does this, okay. Now and also you need to know that the speech exactly which is going to be delivered by the governor is actually not written by the governor, it is written by the cabinet itself, okay. As we all know, governor is a ceremonial head, okay, and he cannot take the duty upon himself to write, okay, he is representing the government, okay, as a ceremonial head, and hence the speech is actually written by the cabinet itself, okay. So, and the next one is the right to debate clause, this is clause number 2. So the clause ensures that the governor's speech isn't just a formality, it is a motion of thanks, and the assembly must be given time to debate over the speech, and if the governor skips the part of the speech or walks out, it creates a procedural vacuum, okay. Now the governor is actually supposed to deliver a speech mentioning what is going to be discussed, okay, and now this is not just a formality speech, okay, this is a motion of thanks which is being voted upon, okay. Now before it is getting voted upon, it needs to be debated, okay, unless and until you debate about it, you cannot reach to a conclusion. End of the day, we are a democracy, okay. So now if a governor walks out without actually delivering the speech, now where is the point to debate? It creates a vacuum, and now we will see what exactly, there are a few case laws which are related to this issue, okay. The first case law is the foundational case law, which is the Shamsher Singh versus State of Punjab of 1974, okay. So now the court in this case has unilaterally held that the governor must exercise all the functions, executive and legislative, on the aid and advice of the Council of Ministers, except for a few areas where the discretionary clause is there. And next, the mouthpiece logic, which is, the court famously said that the governor is the formal or the constitutional head. This means that when the governor speaks in the assembly, they are not speaking for themselves, they are the voice of the elected government, as I have said already, okay. So, and now the court has also given the warning, where the court warned that if the governor acts independently of the cabinet, it would subvert the parliamentary system and turn the office into a colonial authority, okay. So now, as I already said, in a democracy, the elected government takes the calls, elected government frames the policies, okay, not we are a democracy, okay. Now that being said, a position where the executive, who is executive here, the governor, if he takes call unilaterally, except for those where the constitution has given him or her the discretionary rights, if the governor tries to breach over the executive or the legislative function, it is said to be unconstitutional, okay. And the in the Shamsher Singh case, the Supreme Court has actually warned, saying that if there is any breach of the foresaid things, then it would be treated as a subverting the constitutional authority. Okay. Now, so the next case is the Nabam Rebia versus Deputy Speaker in 2026. Okay. So now this case was very important. This case is one of the very important case with respect to the governor. It actually had a five judge bench which ruled over the discretionary power under Article 163, and it is said that it is strictly limited to the powers which are actually provided only in the Constitution. Even the excess of the discretionary powers should be excised with respect to the principles provided in the Constitution. And next one, the address is not discretionary, okay, which means that the speech that the governor is giving before the session, it is not discretionary per se, but it is under Article 175. The special address under Article 176 is an executive function, okay, and this must be performed strictly on the aid and advice of the cabinet. Okay. Yeah, and it has also said that it is no power to edit because the address is an executive function. Okay, and the governor has no legal right to delete or add paragraphs to a cabinet approved speech. Okay, so and this would be treated as vetoing. Okay, in Nabam Rebia case, it is perfectly and clearly the Supreme Court has said that there shouldn't be the speech which is to be delivered by the governor is not discretion upon his or her own. It has to be followed with respect to what the cabinet has decided, and any deletion, any omission or any modification would be treated as a vetoing process. Okay, so this is one of the cases. There are a few High Court cases as well with respect to the speech of the governor which he is supposed to deliver before summoning the House. Now, the first one is the deemed to be delivered rule, which has evolved in the Yogendra Singh Handa versus State of Rajasthan in 1967. Okay, so now the Rajasthan court held that if the governor reads only a portion of the speech, like the first and the last lines, and then leaves the speech, then the speech is deemed to have been delivered. Okay, this is what has exactly happened in the Kerala. Okay, now the second one is the procedural irregularity principle. Okay, so now this says that the Calcutta High Court ruled that the governor cannot refuse to deliver the address because it is his constitutional duty. However, if they fail to do it properly, which is by walking out, and then it is considered as a procedural irregularity, not as an illegality. Okay, and that would nullify the entire session of the House. Okay, so yeah, this is the second, and we will see the possible solutions for the current issue that is going on, and we will divide these solutions into three heads. The first solution with respect to the judicial solution that it has given, enforcing the Nabam Rebia judgment, where the court reiterated that the Article 176 is an executive act and it is binding under Article 163, which is aid and advice, which means that the governor cannot act in his own discretion and he should act with respect to the aid and advice of the cabinet government, okay, cabinet of the state, and also the abolishing the censor power, where the judicial clarification is needed to state that the governor has no power to veto or omit, okay, and he has the accountability to read as it is there, which is presented by the state elected government. And next one is the Shamsher Singh rule, where the court has already called the public disagreement by a governor as unconstitutional fox, and the solution is to classify any deviation from the prepared text as a constitutional impropriety that could lead to a judicial censure. Okay, so and this is one of the angle where the judicial solution can be given. And next one is the legislative solution, where the procedure and the rules of the House are to be modified. The first one is the deemed delivery protocol. The state can opt a rule stating that once the cabinet approves the speech and it is laid onto the table of the House, it is legally considered to be as read full, and even if the governor skips a part of it, it is said to be have passed. Okay. Now the deemed to be delivered principle, which is actually said in the Yogendra Singh case, now that can be directly put as a rule, okay, to avoid any further issues. And next is the recording the cabinet text only. As seen in the Tamil Nadu case, the assembly can pass the resolution to record only the printed version of the printed version which is approved by the cabinet only. So this can also be done. Okay. And next, the final is the executive. The final is the executive reforms, and we will see that a few commissions such as Sarkaria Commission and Punchhi Commissions have also given a few suggestions on this. And the first suggestion is that the motion of thanks as only the forum. Okay, the commission recommended that the governor must recognize the sole mechanism for debating the speech is the motion of thanks, and the governor has concern about the speech. They should communicate with the CM privately, but do not express it publicly. Okay, this is the recommendation given by the Sarkaria Commission. And next one is the establish a pre-session consultation. Okay, and now before delivering the speech, actually the government has to submit the speech 7 to 10 days before. If the governor has any issues with respect to that speech, then what the governor can do is, we can actually say that, see, I have a few issues with respect to speech. Okay, you can just modify the speech and give it to me, and then I will deliver it. Okay, so this will create a mechanism where there is a proper protocol or proper process. Okay, and also there is sort of due deliberation which is followed. And next one is the upholding the constitutional morality. With the Punchhi Commission actually emphasize that the governor should act according to the level of the constitutional morality, and he should not act as a political agent of the center per se. Okay, and we live in a democracy, and this democracy which is based on the constitution, and the constitution runs on the constitutional morality. Okay, so the governor should not act as a political agent, but he should act as a constitutional head with respect to the particular state. Okay, so this is the whole on analysis of the particular issue that is going on with respect to governor's speech. I hope you have understood whatever we have discussed, and I hope this was be helpful for you. Okay, thank you so much.